In this video, we are going to study Section 52 of the Transfer of Property Act 1882. I have provided the link of the previous videos in the description box, which you can check it out. So let's start the video. Lis Pendens. Section 52 of the Transfer of Property Act lays down that during the pendency in any court having authority within the limits of India, excluding the state of Jammu and Kashmir, or established beyond such limits by the central government, of any suit or proceeding which is not collusive, and in which any right to immovable property is directly and specifically in question, the property cannot be transferred or otherwise dealt with by any party to the suit or proceeding, so as to affect the right of any other party thereto, under any decree or order which may be made therein, except under the authority of the court, and on such terms as it may impose. Explanation. For the purpose of this section, the pendency of a suit or proceeding shall be deemed to commence from the date of the presentation of the plaint, or the institution of the proceeding in a court of competent jurisdiction, and to continue until the suit or proceeding has been disposed of by a final decree or order, and complete satisfaction or discharge of such decree or order has been obtained, or has become unobtainable by reason of the expiration of any period of limitation prescribed for the execution thereof by any law for the time being in force. Thus, this section provides that during the pendency of suits in any court which has jurisdiction within the borders of India other than the state of Jammu and Kashmir, or in any court which have been established by the central government beyond the limits of India, and such suit is not collusive and directly and specifically involves any right to immovable property in question, the property cannot be transferred or otherwise dealt with by any party to the suit or proceeding, so as to affect the right of the other party to the suit, under any decree or order which have been made by the court thereunder, except under the authority of the court, and on such terms as it may impose. For the purpose of this section, the suitability of the suit or proceeding shall be deemed to commence from the date of the presentation of the plaint, or the institution of the proceeding in a court of competent jurisdiction, and continue until the suit or proceeding has been disposed by a decree or final order, and the full satisfaction or discharge of such decree or order has been obtained, or is unsustainable by the expiration of any limitation period prescribed for the time being enforced by any law in effect. This section is based on the English common law maxim ut lit pendens nihil innovator, that is, during litigation, nothing new should be introduced. This doctrine aims at the prevention of multiplicity of suits. The principle on which the doctrine rests is explained in the leading case of Bellamy versus Sunnyby, where Lord Cranworth said that the foundation of the doctrine of Lis Pendens does not rest upon notice, actual or constructive. It rests solely upon necessity. The necessity that neither party to the litigation should alienate the property in dispute so as to affect the opponent. Where there is litigation between two persons in regard to some immovable property, and one of them transfer the subject matter of the litigation, a conflict may arise between the right of the transferee and the rights of the parties as declared by the decree of the court. The doctrine of Lis Pendens may be stated as pedant light. Neither party to a litigation can alienate the property in dispute so as to affect his opponent. The result of this doctrine is that a transfer of property pending in a suit in which any right to the property is being litigated, and to which the transferee is a party, takes it, subject to the judgment in the suit, although he was not aware at the date of his transfer of the Lis Pendens pending suit. Section 52 of the Act deals with the suit or proceedings concerning a immovable property. The suit or proceeding pending should be qua immovable property. The right to immovable property has to be directly and specifically in question in the said suit or proceeding. Then only Section 52 of the Act would be applicable. Section 52, when analyzed, shows that it is in two parts. The first part lays down the conditions for the applicability of the doctrine. The second part lays down what are the consequences if the doctrine applies. The conditions for the applicability of the doctrine are: number 1, that a suit or proceeding should be pending; number 2, that it should not be collusive; number 3, that it should be a suit or proceeding in which any right to immovable property is directly and specifically in question; number 4, that the suit should be pending in a court having jurisdiction; and number 5, that the court must be in India or beyond India but established by the central government. The leading case on this doctrine in India is Fiaz Hussain Khan versus Parag Narayan, in which the Privy Council quoted with approval the observation of Turner, learned judge in Bellamy's case, and many other cases in this country involving the question of Lis Pendens have been decided on the same principle. The rule is not based on the doctrine of notice, but an expediency is that the necessity for final adjudication. The effect of the applicability of the doctrine is that it does not annul the conveyance, but only renders it subservient to rights of the parties to the litigation.